Welcome to FOXSOUL's Black Report with special coverage and insight on Derek Chauvin's murder trial in the death of George Floyd. I'm Demi.
Hey there, I'm Brooke.
And I'm Melissa.
Romeo's out today.
All right, on today's show, we are talking live with one of the few prosecutors who has convicted a police officer for killing a black man. Stephanie Morales is the Commonwealth Attorney of Portsmouth, Virginia, and she is here, and it's going to be a great conversation.
We're highlighting today's testimonies and proceedings in the trial of Derek Chauvin, and we'll take a look at the trending headlines for the justice of George Floyd.
Co-founder of Our Black Party, Dr. Wes Bellamy, joins us to discuss just how Our Black Party is mobilizing for a legislation and policy shift for police and criminal justice reform.
That's right, we have all that and so much more. It's our voice, our truth, so let's talk about it.
To me, this reeks of conflict of interest.
Do we know if he actually waved a gun? We only hear one side of the story.
This just really did make me feel good that the justice system did what they needed to do.
We're going to keep following this story, and we will have the latest for you. All right, it is day 4 of Derek Chauvin's murder trial in the death of George Floyd. Courtney Ross was on the witness stand today. She was Floyd's girlfriend at the time of his death. She testified that, they dated nearly 3 years. We also heard from several paramedics who were dispatched to the scene that day last May of Floyd's arrest. A little refresher, in case you're not familiar, Shoven is charged with unintentional second-degree murder, third-degree murder, and manslaughter. Melissa.
Joining us now is Commonwealth Attorney of Portsmouth, Virginia, Stephanie Morales, who is one of the few prosecutors that has convicted a police officer for the killing of a black man. Welcome, Stephanie.
Thank you for having me. Glad to be with you tonight.
Yes, we are so glad to have you as well. Before we get into the Chauvin trial, let's talk a little bit about your professional history. Several months after you were elected to be Portsmouth's Commonwealth Attorney, you successfully prosecuted a white cop for shooting an unarmed black teen in a Walmart parking lot. Can you tell us a little bit about that experience and if you had any fear prosecuting a cop?
Yes, so I got elected for the first time in February of 2015. And in April of 2015, we lost William Chapman II at the hands of police officer Stephen Rankin in my city. I decided, very early on in that process that I was going to handle that matter myself, that I was going to lead the investigation, and I would be sitting first chair after we determined that we were moving for indictments. When the indictments came down, it was a marathon. There was no sprint to justice in this matter, but the case was fought through a year of pretrial motions and then a week-long jury trial, which resulted in a voluntary manslaughter conviction. There was no fear for me. This is the job that I'm elected to do, to keep communities safe. And oftentimes we need to keep our communities safe from state actors who harm people and oftentimes are not held accountable. So that was the fast version. But what the most important thing was that I learned was that it was highly important to center the voices of my victim's family, to hear the voices of the community, and to fight hard, as if our lives depended on them, because our lives do depend on our fight for justice in situations like this, and on prosecutors and leaders making it clear that it will not be tolerated for members who are, they're in place to protect and serve, to actually harm people instead.
Amen.
Thank you again so much for being here. We do want to get to Derek Chauvin's murder trial. The world is watching right now. And during voir dire, multiple prospective jurors said, they had only seen clips of George Floyd's death. And now the seated jury has been shown several different police body cam videos, different angles, things none of us have seen. Can you talk about the impact this new video might have on jurors?
So it's an important thing to talk about the impact that the evidence is having on jurors, because it depends on the juror. It depends on their heart for this individual who lost his life. For all of us on this, on this program tonight, we are certainly devastated. We're heartbroken, and we have been for, the entire time that this has been going on. But we have to acknowledge that who is seated on a jury matters. And so it's highly important for anybody who is listening right now to understand that when you get jury service, you can't have a doctor's appointment for a month. You can't call in sick. We need people on juries who will relate to George Floyd, who will relate to all of the witnesses who have been talking about how they wanted to provide help but could not. And that they are not sympathetic to a police officer who was sworn to protect and serve, but who did grave harm. And so the perspective of the jurors and their common sense and their life experiences are going to play heavily into the decisions that they make on this case. And we have to acknowledge that. We cannot just assume that everyone is going to feel the same things that we feel.
Stephanie, that's a great point, and I do feel like we've seen that in the last 4 days. Now, we've seen several emotional witnesses. New body cam footage came in showing George Floyd begging and fighting for his life. How do you feel this will affect the defense team?
Well, traditionally, defense attorneys are very focused on proving that there is, not guilt beyond a reasonable doubt. And so their strategy is going to hinge on showing that there's a reasonable doubt. And sometimes defense attorneys will work to sow seeds of confusion to potentially prove that he felt that he was justified in taking the actions that he took. But one thing that's very important for jurors to know, and hopefully the prosecution will get into this, is that when there is a use of force, that use of force has to be proportionate to the amount of harm perceived. And one of the things that came out today was that there were at least 5 minutes where George Floyd had passed away, where Derek Chauvin's knee was still on this gentleman's neck. And we know that at the point where he passed away, the harm had long passed. Any potential threat had long passed. He had him subdued for so long. And the moment where the necessity ends for that type of conduct to potentially keep you safe, if you feel there's a threat, that's the moment your use of force is supposed to stop. And so the defense may be trying to sow that seed of confusion, but hopefully the prosecution will, window in on the fact that he had a perspective and everyone else who was around and close by could see that there was no threat. And he continued on with that use of force that resulted in Mr. Floyd's life being lost.
Stephanie, you're absolutely right. Today's testimony was very perfunctory because we had a lot of experts on the stand, but it was riveting because of all the details that came out. And but the burden of proof falls on the prosecution. So the defense has to do 3 things: don't believe your eyes, my experts are better, and the witnesses are not credible or biased. What are the chances that they're going to put Shoven on the stand?
Well, I will say, looking at my case, we put on, the witnesses who were on the scene, we put on experts, and we made it very clear what transpired. And, the officer in my case, he ended up testifying because there was really no one else who could speak to his perspective on why he did this after all of the witnesses testified that my victim's hands were clearly in the air and there was no weapon. And so in this case, it seems as though the evidence is very clearly coming out to show that there was no threat that warranted the type of conduct and the use of force that Derek Chauvin used on Mr. George Floyd. And so I would not be surprised if he did testify, because he is going to have to give an account of his state of mind as to why he did what he did. But it is the jury's job to focus on whether that state of mind is reasonable and whether that use of force was proportionate. And I think we can see very clearly that it was not. But again, I don't know who else could speak to his state of mind other than him.
Right.
So the defense is going to be, if this happens and we do see him on the stand, the defense is going to be trying to, get him to explain a reasonable state of mind. I'm curious what you think the prosecutors will be looking to ask him.
Well, I think the prosecutors will be looking to lay out what happened from his own perspective, because there are witnesses who very credibly testify, professionals who testify very clearly about what happened. This was captured on video. And so it's going to be a very tough thing for Derek Chauvin to disprove anything that was said. And so I would be looking, to clarify and to reiterate everything that had come out in evidence and see how he thinks he can overcome that. So it will be, something that none of us can anticipate what he would say, because again, the evidence is coming out very clearly and there's video. So that's an uphill battle for the defense to climb. I would never give any, advice or suggestions to help them in any way, but I don't see how he could get around or navigate the facts that we're seeing and the evidence that's so clear and that's documented.
So I want to get your opinion as a prosecutor. What are your thoughts on qualified immunity and the Police Bill of Rights?
So qualified immunity is something that I'm happy to talk about as we see this criminal trial going on, because qualified immunity impacts civil liability and financial culpability, whereas the trial that we're seeing now is about criminal responsibility and culpability. And so what happens with qualified immunity is when these officers, they harm people and they result in the loss of life and all of these damaging things to families and communities, oftentimes city governments pay out settlements that come from taxpayer dollars. And so our communities are being held liable and responsible for the state sanctioned acts of these officers who are killing people. And so it is important to know that ending qualified immunity is important, but that does not prevent criminal culpability. And so prosecutors who are willing to fight that fight, they can fight it. I have done it. We're seeing it play out now, and it's not hampered by qualified immunity. So while it needs to be ended, it does not stop or interfere with criminal culpability and responsibility, as many of the members of our community face for everyday crimes without hesitation. And as far as the Police Bill of Rights, the most pertinent thing that pertains to this trial right now is the idea that police officers who engage in use of force and often loss of life, that there should be a waiting period before they are interviewed by law enforcement. And I say to that, we should not have any extra opportunity for members of our community who are actually employed to protect and serve to have a different chance at justice than other members of our community. We have people who look like us, who come through the court system every day, who are not given a waiting period before they are questioned, and they're not given that level of respect or deference. And so we should not be treating police officers any differently from the members of our community who come through the court system and the legal system every single day. And so for me, I am always an advocate for equity, and that is not an equitable practice.
Stephanie, I wholeheartedly agree with that sentiment. Let's switch gears and talk about the district attorney's office. DAs are often in a position to ascend to power through high conviction rates and sometimes compromise the process for a win. How often do you think that this occurs? And as the Commonwealth Attorney of Portsmouth, Virginia, how are you trying to make this process a fair one?
So for me, being elected since 2015, I have been around fighting for transformative change since before there was a progressive prosecutor movement, a progressive prosecutor wave, or before we were even talking about progressive prosecutors. Because I am someone who I identify as a Black woman first, as a public servant second, and as a prosecutor after all of that. And so for me, I want to see total healing, total wellness, and investment into community. And when we have a system of mass incarceration that is not making our community safer, we know that procedurally we are getting this wrong as a system, and it is unjust from beginning to end. And so I have focused in on ensuring that I have prosecutors that are wanting to fight every single day on every matter. They're not looking at cases as a file or a case number, but they're looking at the individuals and the impact that incarceration has had on generations of people. And so we cannot go in court and think that our job is only in the courtroom and that we're making a difference, even if we're treating people fairly and equitably. I think we now have to expand in arguing and fighting for the reallocation of resources, seeking different outcomes, providing for arguments where we're looking at ending food insecurity, we're fighting for fair housing, we're trying to end the school to prison pipeline, and we're stepping outside of that role as prosecutors, but looking at being public servants. I know that I have the power and the wherewithal to do it. And I don't live in a jurisdiction where we are plentiful with resources in the way that some others are. And so I call on my colleagues and my counterparts to do everything in their power to be fair on every single case and equitable. That should be the easy thing. But beyond that, we have to step outside of this traditional role and fight every day to reverse the wrongs that this system has done to the Black community and all marginalized communities for so long.
Yeah. Stephanie, do you think Chauvin's charges are legally sufficient? Obviously, first-degree murder to everyone watching sounds more serious. And, the family's attorney, Ben Crump, questioned why that wasn't on the table. I'm curious, what do you think?
So I will share that in my case, we ended up with a voluntary manslaughter conviction, but I sought first-degree murder indictments and was successful with that. So we actually began with a first-degree murder indictment, and second-degree murder and voluntary manslaughter were lesser included offenses in Virginia. So I felt, based on all of the evidence that I had, that there was probable cause to charge with premeditated murder, which is first degree. And so that gave us the opportunity to have the jury hear all of the facts and the evidence and make a determination about whether they felt it was premeditated, whether they thought it was not premeditated but done maliciously, or whether they thought it was done in the heat of passion. And so that was the option that we were able to provide the jury with the law in Virginia, where you are able to consider lesser included offenses. My understanding in Minnesota is that the first degree would also be premeditated. The thing that many people don't understand is premeditated murder is not like what we see in the movies, where you have someone planning for weeks and weeks. There are legal doctrines that state that premeditation can be formed in an instant. And so in this case, where again, we see Derek Chauvin holding his knee on the neck of Mr. George Floyd, long past the time where any threat could be argued, the necessity for this conduct had long ended. At what point did he potentially decide, I'm not letting him up, I'm going to kill him? There is a wonderful argument to be made that there was premeditation, and that premeditation, although it may have been formed quickly, that he made a decision about what he was going to do. And there's nothing to indicate that there's not probable cause to see that. So I think that would have been appropriate. But again, I'm not present in Minnesota. I'm not as familiar with the law as I am in Virginia. And ultimately, the prosecutors had to do what they felt that they would be successful on. And I don't know the doctrines with lesser included offenses there and whether that was not on the table. From what I have gathered in terms of my research into the law there, I believe that they are able to seek lesser included offenses, meaning the jury can say, we're going to find you not guilty of first degree, but we will find you guilty of second, or we're not going to find you guilty of second, but we will find you guilty of third. So again, I respect their judgment, but I do believe there's an argument to be made that first degree murder with premeditation was appropriate in this matter.
Stephanie, I agree with you wholeheartedly. I think I speak for everybody when, watching everything. What we see is Chauvin acting with not only a lack of empathy, a lack of critical thinking, but complete immunity, and callousness. The hand in the pocket is just what did it for me. Before we let you go, I just have one question, because what came up a lot today in the testimony was called spark of life testimony. And it's something that is not allowed in many, states other than Minnesota. Can you speak towards how effective spark of life testimony can be in humanizing the deceased?
So I shared, and I've shared with many people, and I continue to share this, that I am not actively watching this trial. Because I have what's referred to as vicarious trauma, where because of the work that I do and the things that I see and working on these cases, it's simply too heartbreaking for me, and I have to protect my peace. So I'm getting the information about this case. I'm following it secondhand, but it's too much for me to watch. But if you are referring to the instances where individuals testified about what type of person he was.
Yes.
So I thought that was what you were referring to, where there was his ex-girlfriend who talked about how they met and how he asked if he could pray for her when she was having a bad day. It is critically important because we need for people to see this beautiful human being as the brilliant man that he was. And so, I wish all states had an opportunity, and not just in officer-involved shooting cases, but in all cases, to show the human side of individuals, because people are not, first of all, George Floyd is not on trial. That's one thing. But he is a human being. He was a father. He was loved. He was an amazing person. And it's critically important for this jury to understand that, because again, depending who sits on that jury, they may not understand who this individual is. They may not see him as we do, as someone who could be our brother, our father, our uncle. And so anything that can be done to ensure that that jury sees this person, they see the soul that was taken away from us based on this, action, by someone, again, who was supposed to be there to protect and serve. It is critically important. And I truly hope they were paying very close attention. And I hope for everyone who was a part of the viewing audience, the at-home jury who's watching this, I hope you never forget how this makes you feel, and that you understand the importance and how imperative it is for you to take that jury duty service very seriously. And if you have never received a jury questionnaire to serve, that you go down to your clerk's office and say, why have I not received my opportunity to take part in this civic duty that is so important in finding accountability for individuals who've been harmed, families, and our communities at large.
Stephanie Morales, we cannot thank you enough for joining us today. You have been fantastic. You are welcome back to the Black Report anytime.
Thank you so much.
Absolutely.